Welcome to another production of Gibby's Treasures.
All right, welcome back again, everyone. This is part 2. And stop right now if you have not watched the first one. Head back over there and come back and watch this one. So let's get started. And we'll continue this right here. And let's hear what he has to say.
Back to the traffic matter, you definitely want to file the notice to the city attorneys. You definitely want to start out by getting all their anti-bribery statements for the officers and stuff, because if the officers don't have an anti-bribery statement, he's not a legal officer. You know, he's no different than me coming out there and putting little lights on my truck and saying, pull over. You know, okay, you're going to meet over here at Hardin's Garage for a trial on the 28th, you know, and I'll decide if you're guilty or not, you know.
Bring plenty of money.
Right, bring plenty of money, because I might hold you hostage in the doghouse and back if you don't, you know. And that's the difference, you know. There is no difference. There is no difference between what I just said and that guy with the gun and a badge on and driving a car that's marked police. If he doesn't have an anti-bribery statement on file, he is not an officer. And if that judge don't have an oath of office on file, he's not a judge.
They're impersonating.
Exactly. They're acting.
They have to have an oath.
Yeah, they have to have an oath of office. Every judge has to have an oath of office.
Every public official.
Yes, has to be sworn in.
Even on file board member. On
Yes.
file with who?
On file with the Secretary of State. And that...
It's Article 16, Section 1 of the Texas Constitution.
And by the way, this was a mistake I made on this, and I appreciate if everybody would cross out my credit card number.
I wondered about that.
Yeah.
I said, geez,
I'm like, man, it just hit me. I'm like, woo, just give out this with my credit card number.
You changed a couple of digits on that?
Yeah.
The other one in the computer, you might want to go get that one right now.
No doubt.
Because they can go in and, you know,
Yeah.
do all kinds of fancy stuff.
Yeah.
So I shouldn't have faxed this to all my friends up in New York.
So what you do is put your credit card number on there or whatever. If not, you can. That's to have it, you know, overnighted and to have it immediate if you want it processed quickly. You know, I use a credit card.
Don't cross it out, you know.
You can also do this by email. I've done that.
Yeah.
Really? The Riegler. Yeah, he'll take it and you give him the information and he'll do it.
What's his email address?
I just got a couple bills to pay.
Dave Riegler at sos.tx.us or something like that.
.gov.
Or something.
I don't remember off the top of my head. It's been a while since I've seen it.
And also, when you send out to the Secretary of State, you want to, what they'll do a lot of times is when you ask for this oath, they don't have it. And then they contact them and say, hey, this guy just requested, you know, your oath, and that's not on file. So they run down there and they get an oath done and swear in, and now they send you a certified copy of his oath, which is absolutely valid now. So what you do is like
They
here.
have to have the date on where you took that oath from.
Well, you're right. And if you don't want to continually fight more battles than necessary, you alleviate it in the first letter. Like this one, I said, I want the oath as of November 1st, 2001 or prior. So don't come to me with an oath of office dated after that date, you know, because these incidences happened before November 1st. So I want their oaths as of November 1st or prior, you know. So if it's January 25th of 2002 that you were arrested, then you would say, I want their oaths and anti-bribery statements as of January 20, blah, 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 2002.
Bribery statement, that's in the county. You have to go to the county to get that.
No, you can get it from the Secretary of
Bribery
State.
statement is Secretary of State.
Yes.
Oath of office is local.
You can get it local or from the Secretary of State. She didn't like me.
You have to pay them with a credit card to have you?
No, you can send them. I just did that because I wanted them overnighted. I want them quick.
Right.
And usually, if you just send off for one thing, it'll happen quick. But the deal that I asked for here that they had problems with was the foreign registration of foreign propagandists and foreign agent registration statements. They know that they're representing foreign powers, and they know they don't have this. And the penalty for representing a foreign power and not having said registration on file is 10 years imprisonment. So that is why, to this day, 1 month later to the day, I have not got any of this information back from them. And usually when you do it with a credit card and ask them to FedEx it overnight and charge it to your credit card, it's there in 3 days. You know, you got their oath or their anti-bribery statement.
Now, one other thing, James, excuse me. On a judge now, if he's a visiting judge, see, visiting judges are unlawful because every time a judge changes courts, if he goes from one court to the other, he has to have the oath of that court.
Right. That is right.
So, just because he might have it from one court, but if he's a visiting judge over here, he's unlawful unless he has it with that court too.
That's true.
Wow.
That's a good point. Very good point.
Yeah, talking about that, I know of a guy who's done a suit up Scotland County, but a ways north of here, to get property back that was sold at IRS auction in a trespass by title. And it seemed like the district judge didn't want to do it, so the day it's supposed to have a trial, well, he was too busy with the jury trial, so he turned it over to another judge, which was the county judge there. Well, everything went against him. And he goes to the information Secretary of State, and he asked for a new trial, and I said, oh, okay. You know, no trouble.
Right. Yeah. Yeah, that's another thing. If all fails, it ain't over. And even though they tell you, you have 2 options, okay, and say they had a mock trial, okay, and the judge only gives them certain points to rule on, you know. And you should also have a jury foreman. Every jury should have a jury foreman who informs the rest of the jury of their duties and their rights as a jury. And the judges don't like that. You know, I've had to remind them several occasions, you're not the judge. And he goes, because he says, this is my courtroom. And I said, I object. This is the people's courtroom.
Right.
And it is not your courtroom. He says, I'm the acting judge here. And I said, I object. The jury is the judge. You're just a referee. And he goes, oh, now a judge is a referee and a referee's a judge. And I said, absolutely. That's the way it is. The only reason you're sitting there is to make sure, as a referee, that everything goes by lawful proceedings and that these DAs and attorneys don't have a mock trial. You're there to prevent that because these jury members here, they're not schooled. They didn't go to law school and stuff like that. So they don't know when something like that is going on. And you are merely a referee here to see to it that that doesn't happen. But as far as judge, you're not a judge. You might be called a judge, but you're not a judge. They are my judge right there. Those 12 people in that box right there are my judge. And that's a fact. They are your judges. In the end, they render your judgment. Guilty, not guilty.
But we pass a sentence, right?
Well, no,
Jury,
they do.
Jury does.
No, but do they say, then he'll say, okay, like guilty, okay, then who says, okay, 25 years and $1 million? So who
Well,
says
no,
that part?
he as the referee will give them options that are set up by law. You know, for these crimes, the penalty is this amount of time in prison, up to this amount of time in prison, or this amount of dollars of fines up from 2 to 200, like Bill Martin was told. And they found him guilty and fined him the maximum $200 on every single one of them. And that can happen. And then at the end, the judge can tell you, well, you have 2 options. You can pay the money now, or you can appeal it. And you say, I object. You're trying to coerce me. And he'll be like, what do you mean? I object. There is more than 2 options that I have. I can call for trial de novo, and trial de novo means set a new trial as if the first one never happened. And everyone has the right to trial de novo. So you can totally get rammed and railroaded, and it's not over with. It's okay. You don't have to know how to appeal a case. Just go trial de novo. I want a new trial, and you can get you can get it.
On what basis?
You don't have to give a basis. You just say trial de novo, and it's your right.
A certain judge denied it to me.
Well, he's
See, y'all confusing common law court with equity courts. So, I mean, and the jury and the judge, see, when they keep talking about the judge do this, do that, he can do whatever he wants to in administrative court.
right, and that was my point earlier. You want a judicial proceeding, not administrative proceeding.
What about in family court?
In family court, you want a judicial proceeding also.
Always do.
Always
Family
judicial.
court is administrative exclusively.
And so you ask for a judicial proceeding.
Don't go into it. Just tell them you're not going into the story here. You want to,
Object
object to it.
right off the bat and ask them. Say, Kenny O'Kane was in a case for taxes, and the first words out of his mouth was, "Is this a administrative proceeding or is this a judicial proceeding?" And the judge goes, "It's judicial and administrative." And Kenny's like this, and he goes, "Are you with me?" And Kenny goes, "No, I don't think so." You can't have it both ways. Judicial, you can have a judicial proceeding is where you have constitutional rights, and they cannot deprive you of those rights in a judicial proceeding. In administrative, they can quote legislative enactments that are contrary to your constitutional rights, trespass on them, spit on them, and throw them out the door. Bottom line. And actually, ever since they first of all, any bankrupt entity is no longer that as it was before. So the moment the United States declared bankruptcy, we were no longer that as we were before. That's why you used to see on the Olympics and stuff like that, you would see the United States, Now you hear the corporate United States.
Really?
That's why. Absolutely.
You hear that now?
Absolutely. The corporate United States. They admit it. They admit it.
The corporate United States
On the Olympics, they will admit the corporate United States.
Oh, come on now.
I'm telling you what I've seen and heard myself personally. I'm not telling you hearsay. I'm telling you what I've been there and done that. Studied it, seen the documents, or heard it and saw it myself.
Okay, so we send out our notice, so we get a ticket. Let's say you're driving down the street. So we send off this notice to the secretary for the... Now, should you do all of them?
Well, it depends on, where you plan to go.
Okay.
I asked for all these because I plan on making a real big case.
See, let me say one thing, if you don't mind. When you go in there, you got a right to the nature of the cause and a copy of the complaint. You ever see that in the Constitution? All right. A copy of, you want a signed copy, a sworn to signed copy of the complaint.
It's called a verified copy.
Yeah. Now, the county clerk is one that always signs that complaint. So they're swearing they was out there when this happened and an eyewitness to it.
Yes.
And they were known, and they were.
And that's grounds for dismissal right there.
So I ask for a verified copy of the complaint.
Yes.
After I get this stuff from them, before I go to court,
Well,
this,
you
then when I
get
get
this,
there, I go ahead and ask them for that.
and you file a motion invoking the common law jurisdiction of the court, and objecting, a notice of motion for dismissal for lack of jurisdiction. Every time, lack of jurisdiction. You are lacking jurisdiction to even hear this matter.
Yeah, another thing
One
too,
other
you talk
thing you need to do when you go in there.
Hold on now. I'm a motion for dismissal, lack of...
Jurisdiction.
Okay.
Now, you need to go in and challenge the law itself. Show me the law that applies to me. The law is
Another point of jurisdiction is Article 5, Section 12 of the Constitution. It says presentment of indictment or information invests the court with jurisdiction. Well, they don't ever do that in practice.
But see, it's still criminal, and you can go in front of the grand jury. You need to go to the grand jury.
Well, it states that clearly in Texas Constitution, Article 1, Section 10, that before you can be indicted, you have to have your right to a grand jury indictment. So if you're not indicted by a grand jury, and if you go in there and say, Mike Hawkins is my co-counsel, and I am myself, and I'm not representing myself, I am myself, and they say he has to be a member of the bar, and you say, show me the law, like he's saying. Under Article 1, Section 10, it says I have the right to represent myself or by counsel or by both. Where in there does it say a member of the bar? Where does it say attorney? It doesn't. It says counsel. He's my counsel.
And the federal Constitution tells you have a right to counsel.
I argued that before an associate judge, which is a non-elected judge, as you know. I didn't know it at the time. And the fourth definition of counsel out of Webster's dictionary was a counselor at law. The three prior definitions had to do with someone that gave you advice or information.
Well, is it still, even with that definition, I didn't hear member of the bar. And I didn't hear attorney. So where do they construe everything to become, you have to be a member of the bar? You know, you don't have to be an attorney. You don't have to be a member of the bar. And you cannot produce documents that back up what you're saying. You're talking, but you have no evidence to back up what you're saying. If you don't have evidence to back up the talk you're talking, then don't try to walk the walk. You're not walking over me. Not with the talk. You got to have evidence, you know. And if they can't produce it, then just keep objecting. I object. You're violating my constitutional right to my choice of counsel. And my choice of counsel is this 6'7" guy with the big old red beard, 300-pounder. And no, he's not a member of the bar, and no, he's not an attorney. But you're saying that he has to be. Well, prove it. Show me the documents.
Show me the law.
Right, show me the law that
Always
says this
remember, show me
stuff
the law.
that you're talking about.
You also cannot use a Webster's dictionary in a courtroom. You have to use a Black's Law Dictionary because they're very, very different.
Yes.
And a definition out of Webster's carries no authority in a courtroom. It has to be Black's.
And as does Black's Law carries no authority in the Supreme Court. There's only one dictionary recognized in the Supreme Court, and that's Bouvier's.
1856 Bouvier.
Right. And 1856 Bouvier's is what's quoted in these motions. So,
Well, that shouldn't be. It should be common.
well,
Common dictionary for the common person to understand
go by the
common language that's
Right.
used.
see these other dictionaries.
That's in conflict with the objective of government. They got to keep you confused.
See, there's one other thing too. When he on this grand jury, what the DA will do, he said, "Well, I have information of so and so." I have a very, very serious problem with that word information being in there. Now, if he does do that, ask him to show me the information that you have. And he said, "Well, I have this witness supplying me with information." But the law says 2 or more witnesses. It says witnesses.
Right.
Got to be 2 or more.
Right.
Maximum law, 1 witness is no witness.
Right.
But I really have a problem with that word information that they slipped into that Constitution and that state Constitution.
Yeah. They have.
Because they can go out there and yoke up some junkie somewhere.
Right.
And, you know,
And that's what they do. Exactly what they do. They have their little informants and stuff. They busted with heroin and everything else, and they make deals with them, you know.
yeah.
We won't
But
throw
that's
you in
the
jail,
reason
but
Jesus
you're
said
going to
right
be an
away.
informant for me now. And then whenever they meet a fumble bunny or guinea pig in the court, they use them.
Yeah,
That's the reason
they're not
Jesus-
as much of an informant as they are a mannequin.
Reason
Right.
Jesus said, bring me
Tell you
two
to say.
witnesses.
You know, we're
Two
not asking you
witnesses.
for information,
Bring
we're
two.
asking you for
Not one.
performance.
Yep,
That's where they come from, Jefferson.
that's a fact. So you get that information on them, and then you file in as an exhibit, exhibits. And you mark your exhibits, exhibit. I like doing it A1, A2, A3 because I might end up putting 500,000 pieces of paper in that case. And if I just do it 1 through 5, or 1 through 10, then I run out of room. If I do it A1, A2, A3, then I can go as far as they can count and then go B1, B2, B3, So I always do it that way. Enter exhibits as A1, A2, A3 like that so that I can always go to B2 or B3 and C3 and C4. And also you can set up your case in different ways to where they know A exhibits have this kind of information, B exhibits have that kind of information, And you can't ever put enough exhibits to exonerate you, Highlight out of your Texas Constitution, Article 1, Section 10, and highlight it and enter it as exhibit number 1,
What was that again?
Article 1, Section 10. And then argue the fact of where's the separation of powers. They're in all violation. Yep, Article 2, Section 1 clearly states that 3 branches of government must stay distinct. Administrative, legislative, and executive, administrative, and judicial. And that in no way, shape, or form can those 3 intertwine or have an influence into the others. Yet, these corporations and the bar are creating legislation depriving us of our rights and then using judicial proceedings to enforce it. Well, that's in violation.
What you need to do on these, when you're going down on the code or whatever, tell them you want to see the enacting clauses enacted by the legislature and the enabling clause.
Yeah.
Where they got the authority on the Constitution to do it.
And the public law. See, like Title 26 of the Internal Revenue Code of the United States Code. Under the 50 titles listed under the United States Code, Title 26 has never been enacted as substantive public law. It is private law.
For something to be a law, there's 4 things you have to have. It has to be enacted by the legislature. It's got to have the enabling clause. It's got to be authenticated by the Secretary of State, and it has to be published.
Right.
If any one of those 4 things are missing, it's a code or a regulation or a statute.
Right.
It's something else besides the law.
Right.
They love to use law when they can. That's
And
when
they call it law.
all these codes and regulations, all that kind of stuff.
Right.
Authenticated by who?
Secretary of State.
Uh,
And that's the point I was trying to make with the Title 26 of the United States Code. You look up in Bouvier's dictionary, and it says private law relates to private matters and does not relate to the general public at large. So, if private law relates to private matters and does not pertain to the general public at large, then how are you trying to tell me that I am lawfully bound to obey Title 26? It has never been enacted as substantive public law, which means it's missing those 4 clauses.
one of the 4 things in there.
Right. And that's a fact. It clearly states right next to each title, they'll say public law, blah, 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 blah. Public law, blah, blah, blah. Go to Title 26.
And what is that? Title 26.
Internal Revenue Code. And that's another thing. If you want to, people say, I don't want the Social Security number. It's the mark of the beast. And people don't know why it's the mark of the beast. Well, other than the fact that they are giving it to you at birth now, and when it was first instituted, it was stated that you had to be of age because you were signing into contract to be able to get that Social Security number. Well, since the Emergency Act of 1935, No,
You said
35.
33 before.
Well,
No, that's when they declared bankruptcy. But this
The Emergency War Powers
Act, Resolution Act of 1935, as amended 1939, Section 666,
No.
sets out the
No.
Social Security. Yes.
Section 666.
Section
Yeah, that's
666.
new, though. Section 666 just went into effect in, what, about 99?
No. If you look it up, and I learned that from John Nelson, and it's in a seminar back from 1996 that he did in Dallas. He talks about it. The Emergency Resolution Act of 1935, as amended 1939, Section 666, gives forth the Social Security Amendment Act. So,
You know what we're missing though? All these groups, different groups fighting around here, saying all these tickets and taxes and all this. What they're doing is forcing us into one of their courts. We have to get our county court back where the county judge resides.
right?
Get state constitution, you can read Article 5, Sections 16, 17, and 18. You can go over, 15, 16, and 17. You can go over and read Section 29. You see. The only place where our power is in the county itself. It's in that county court where the county judge resides. He's elected by the people. That's the only court we're supposed to go into. And it has to be an injured party when we go in. It has to be a court elect that.
Right.
Or there's no injured party, no case.
That's another argument that I have used that has worked in traffic is, in order to deprive me of life, liberty, or property, and my money is my property, there must be an injured party, a corpus delicti. A corpus delicti means an injured party. And I've argued that fact with the judge and said, where's the corpus delicti? The state is the plaintiff, I'm the defendant, and if the state has damages, I want to put the state on the stand, and if he ain't crippled and mangled and walking funny when he gets up there, or bleeding still, then there's obviously no injured party, and if there's no injured party, you can't have me here and deprive me of life, liberty, or property, which includes, but is not limiting to, my money. And your bottom line is I can get out of all this for money. If I pay for this, you'll dismiss it.
It's extortion. No?
Exactly.
You can do whatever you want to.
And when I told the judge that, I said, where's the injured party? And I don't want that officer coming up here. He ain't injured. The officer is not a witness against you. Not in traffic court. He is
executing the legislation they've created.
Exactly.
To go get anybody who does that.
And he's not
Bring him here and make
the
him
injured
money.
party. And the bottom line, to be guilty of any criminal offense, you must have a corpus delicti.
It's like in a murder case, you have to have the body, habeas corpus.
Exactly.
Well, see, all murder cases has to be common law because they have to have an injured party.
Right.
You have to produce that body.
Yeah.
And it's the same way in the courts. You just got to make the judge realize that you know this. And tell him, listen, man, the state is filing suit against me. And if the state has injuries, I want the state on the stand so that I can look at them with my own eyes and know in my heart that I injured them. And if I can't cross-examine, that's another thing. You have the right as a defendant in any criminal defense to cross-examine the injured party. Well, if the injured party can't even be put on the stand because it's been a legislative incorporated municipality.
It's a bankrupt legal fiction.
Exactly. So you just tell them that. Bring forth the corpus delicti. Where's the injured party? Not the officer, that officer. And that's one of the arguments I used, in fact, to win that case where this whole thing with the suspended license started. When I was up there arguing with that. He was trying to bring these people up there as witnesses against me. And I said, I object. This guy's wasting my time and the court's time. Those people's injuries are another time, another court, another matter. We're here today because of damages claimed by the state of Texas. And if the state of Texas can't put a witness up there as itself and say, I'm the state of Texas and this is how I'm injured, I can't walk anymore because he crashed into me, then they can't use them witnesses against you. Just argue that. Say, hey, their damages won't be heard today. That's another day and another court and another whole situation. We're here today to hear about the damages of the state.
The state will always claim that you violated the peace and dignity.
Well, show me the state then. Show me that peace.
Right.
Yeah, well, what criminal offense is that to violate someone's peace and dignity?
Well,
And the answer is it isn't.
right.
Well, also, how can a bankrupt legal fiction have peace or dignity?
It doesn't.
See what you can do when you go into these courts. And then get up there. When they, even a municipal court, even if it's a city, in a municipal court, they'll say if they put Texas in by the state of Texas,
Yeah.
then you can challenge that jurisdiction, tell them I'm here by special appearance. They don't know what you're talking about. You're challenging the jurisdiction of that court.
Right, and that's what that motion that you got tonight states. James D. Harden, by restricted appearance, right off the bat, restricted, not willingly or voluntarily. You can always add that in there. I'm here by restricted appearance, not willingly or voluntarily, but under threat of arrest if I failed to do so. So you can always say that also. But yeah, you're definitely always here by restricted appearance.
You always say special appearance, but restricted do the same thing.
Right. And invoke the common law jurisdiction. If you don't invoke common law jurisdiction, you're going to get railroaded in an administrative proceeding. So invoke the common law jurisdiction every time, because the common law is where your Constitution's at.
Or you power.
Right.
But I wish everybody would read that about the county court. Next time you get the state constitution, read about the county court.
That's Article 5, Section 15, 16, 17, and 29.
Yep. 29 talks about your county commissioner, and it's very important. They're very important too. They play a major role in this thing. You don't hear much of them. They play a major role in this.
Well, the ones who are playing the biggest roles are the ones you never hear about.
Yeah, absolutely.
They don't like to come out in the open in the fresh air and sunshine. They like to hide in the back and send everybody, send law-abiding people like us against each other with guns and badges. Go do my will.
Right.
And get
That's how it's been. Divide and conquer.
Whose money
From the
is their
beginning.
God to get people in the hallways of courtrooms and say, you go ahead and do that shit, I'm going to go ahead and put you in a hole in the ground.
Yep.
James, would it be possible to take all of this fantastic information and put it together in the form of something like a workbook? Because all of us, I have a ticket. I gotta know what to do.
Right.
And I know that of course it seems like every person's case is different. A little distraction back here. But still there are basic procedures that you need to follow.
Yes.
There's kind of a step 1 and a step 2, and there may be, on step 2, if your situation is this, you do this, or if it's this, you do that. But could it be put together in a workbook, instruction manual kind of a thing?
Before James answers, let me throw in a piece of information that you didn't mention. Her ticket was from the county sheriff, and she's due to appear in the JP court. And the JP court, according to statute anyway, is a court of proper jurisdiction, and it does lawfully exist, unlike the Houston courts. And that is going to change how she has to plead it, because I don't think she can go in there and say the court doesn't have jurisdiction. Now, she might be able to demand a judicial hearing instead of an administrative.
She can demand a judicial hearing. She can still file a motion for common law trial by jury, and she can still file a motion for Article 3 court and judge. And you guys should have gotten copies of all these motions. The Article 3 court and judge, they're only sitting there while during good behavior. And if you can prove anything In other words, give them judicial notice.
Right.
You know, are you aware that since we have been under the Emergency War Powers Act? It's the executive order, blah, blah, blah. And now, if he is aware by judicial notice that we are under Emergency War Powers Act and that the courts are to be closed during those times of war, then how could he possibly hold you in any type of criminal offense in that court? He's been judicially noticed now of a fact that has just changed the whole proceeding. And he's only there.
Fringe flag, because they are military courts.
Yes, they are. But thanks to David Windbag Miller, as Standard calls him, Miller versus U.S., he brought all those arguments up and he lost, and now they use it as a case site precedent against you. You know, so if you bring up the gold fringe flag argument, they'll say Miller versus U.S., no standing. You know, so keep that in mind too.
Tell you one thing I noticed about the flag, what I noticed one time on television when they had, whatever his name was, the railroad killer, that one of the appearances where they bring him to court, I noticed there wasn't a gold fringe flag they had up there.
The Supreme Court doesn't have
No,
a
it was Supreme Court, it's district court.
Yeah, but see, now that's because
It's state district court, murder trial.
let me
And, I thought that, the cause of that, and it being murder, that they were going to do some type of common law trial.
Well, now, all murder
So
cases.
I went up to have to be up the courthouse one time, and I asked got to the clerk to get the indictment against him to see how they wrote his name, but they wrote his name in all caps.
Oh yeah, that's standard. They do that
Well,
every
that's
time.
standard. The code fringe flag is also pretty standard.
Yeah, you're
But
right.
see, all murder cases has to be tried in common law.
And if
All
you,
murder cases common law. Even O.J. Simpson thing is common law.
He was never indicted.
Huh?
O.J. Simpson was never indicted.
Well, anyway, it was common law, of course, because it's a murder trial.
Well,
All murder trials are common law.
if you look up Title 4, Section 1 or 2 of the United States Code, it tells you the laws of the flag and tells you who's supposed to have gold fringe or a gold eagle and stuff like that. And only the executive branch is supposed to have any gold fringe on it. And the president's the only one that's supposed to have the eagle at the top of the gold fringe flag. And for instance, the FBI, they're not judicial. Every FBI agents are foreign agents. Their paychecks come from the IMF, bottom line. They're paid by the World Bank. And they're all foreign agents. And for that reason, they don't have authority here. So, if you ever run into something with the FBI that's adverse to you and to your demise, take all the FBI cards you can get, boy, and send off for their foreign agent registration statements, and then file it in court that the punishment to this of under the Foreign Agent Registration Act, for anyone representing a foreign power and not being registered as such, the penalty is 10 years imprisonment. And once you got all their cards, that's admitting that they've talked to you and that they're dealing with you. Same thing with the IRS.
Department of Treasury.
Department of Treasury, that's a little different. It depends on who you're dealing with. The Secretary of the Treasury, Robert Rubin, he's absolutely a traitor, and it's clearly admitted in Title 22 international organizations, where they pronounce him to be their new governor, Secretary of Treasury.
When you talk about some of those, I think there's a number of things there's playing with words, and I think there's the Secretary of Treasury, Department of Treasury and the Treasury Department. I think they're two different things.
Yeah.
And along the same lines, I think the state constitution brings up the assessor and collector of taxes. And I think that's a different office from the tax assessor collector, because why have the two different terms?
I'm not sure about that part.
But But you read in there, it seemed like the description of the tax assessor collector is sort of a lesser office of some kind. And the assessor and collector of taxes is the one that's supposed to make the assessment of the taxes. Well, you don't ever get an assessment. You get sort of a bill, but there's no official signed assessment.
Exactly. Yeah, you're right. You get a
all
bill.
different,
It's really a statement.
yeah, they call them, technically they're municipalities, but they're various agencies will send out different bills. You know, your hospital district taxes, your school district taxes, fire departments, police departments, all this. They administer different taxes, and of course, if you're paying on your house, you don't see it because you know it comes out through your mortgage. But it's all illegal because none of it goes to the assessor. You know, it just they just bill on their own. And I think that's one of the things that Kenny was fighting on this tax thing he's got.
I got to get back moving on that thing. It's pretty good.
And I can
See, what they
definitely
do,
tell
let
you.
me say one thing in Texas. Each state's different. But what they do on these property tax, when you get a notice of foreclosure, the little foreclosure when you sell your house, somebody probably working for the bank to go down and buy that foreclosure. Say if you owe $10,000, they'll go down and pay those taxes. For you to get that house back, you have not only pay the $10,000, but you got to pay 25% interest.
And penalties. You're right.
Okay.
Yep. That's why a lot of folks are starting to figure that out, and they're getting other people to go buy that out instead of doing it themselves.
Yeah.
They're saving tons of money doing it that way, and they're going around. They found a way to get around that little system there.
Yeah.
But one thing,
the price varies in different states. Some states make 50%.
yeah, and some states don't have state tax, and some do. Like Nevada has a state tax, and Texas doesn't. Louisiana has state tax. Florida, you know. But one thing I can definitely say as far as IRS is do Freedom of Information Act requests. We did them, and they had me classified as a high-level drug dealer.
Yeah.
They had Mike Hawkins classified as a truck and chassis manufacturer. Mike was a underground coal miner, and Kenny O'Kane was classified as a truck and chassis manufacturer out of Puerto Rico. They had Leah, somebody else was using her social security number. She was classified as a resident of the Virgin Islands. And so, you know, you get your individual master files back and you mark them up, objecting to everything. And then send them back and say, I want this information corrected. And you put it into your master file. And now they've been put on notice that their books and records are inaccurate. And so when you go to court, if and when they decide to bring you there, if they're dumb enough to, after you've done something like that, then you can show, look at all of these things that they've got me wrongly classified as. And why? It's for a reason. They don't have rights to tax us, but they have rights to tax citizens of Puerto Rico and the Virgin Islands and Guam and
all their enemies.
Right, and so forth. So definitely do Freedom of Information Act requests to the IRS and ask them for your IMF, individual master file. And if you own a business, get your BMF. It's a business master file. And it'll, depending on how long you've been paying and how much money you've made and paid and so forth, I mean, it could, you know, the papers that they open up like this, you know, they're all connected together and they fold back and forth like this. And we've seen files just so thick it's ridiculous. And by the time you go through there and you see all the different class codes and stuff, and we've got all the manuals in the library here that you can decode it yourself if you want. And, you know, 150 means this and 160 means that, you know. And to the average individual, or I should say living soul.
Person.
Well, person is defined as a partnership, corporation, and so on and so forth. It's not ever class. It doesn't say anything about a living soul, you know, and that's why he brought up a good point with the person issue.
Yeah.
There have been others that have argued that also, the person issue, and have been successful with it. Some others haven't, but it's all in how you argue it and how much you know and how quick you come back when the judge says, yeah, you've been studying law. What kind of law? You know, that stuff they rule on in the courts, you know. If you don't come back with constitutional American jurisprudence, you know, then they're going to realize you are incompetent and unable to handle your own legal affairs real quick.
What does jurisprudence mean?
Am jur. It's the conscience of the law. If you look it up in the dictionary, in the Black's Law Dictionary, it says am jur is the conscience of the law. So, I mean, the way I see that is what is your conscience? It is the being itself of the law. And something else to remember is anything that violates the law of nations is a violation of your rights. Because every country, you know, like for instance Hawaii, when we took over Hawaii and put them under as part of territory of the United States, they had to redo their constitution because their constitution that they operated on for however many hundreds of years was not based upon the law of nations. And every constitution with every government that deals with each other, their foundation and their principles must be based off the law of nations. And that was pretty much our forefathers' Bible, if you will, you know, was the law of nations. So, anyway, that's just a 2-hour in general brief of what's going on, and traffic is just a small part of it, and there's a lot bigger picture, and
Well, I'll tell you what, to get it back, we need to get control of our county court. The Robert Republic's out of town and go to him. That's why powers are.
yeah, we need to start going to the courts, and we need to start filing motions and reclaiming. Well, you got to reclaim. They've taken away already, you know. You just got to be man enough to say, I'm the sovereign here, you're not.
And don't forget about that case I told you about, the Lampton versus Smith, 1829 case. Very interesting case.
Alrighty. Yes.
So, you just told us about a hearing that you had. I guess that was a hearing. That was not an arraignment, or was that supposed to be a trial and it got continued to change?
That was the arraignment. I was supposed to go down and make a plea.
You did all that stuff at the arraignment?
Yes.
Okay.
Well, in the municipal court, it ain't gonna happen. You know, you go to the municipal court and you say, you know, give me a verified copy of the complaint. They're going to say, well, until you make a plea, we can't give you that. The issuing citation is the complaint. And you say, well, I object. For the record, I object. But if you say so, and they'll say, you know, you have options, guilty, nolo contendere, or not guilty. You know, that's all we're going to hear today. That's all you're going to be able to say. Guilty, not guilty, or nolo contendere.
You can object to that,
And you can
because there are
object to
6
that.
different pleas that you can enter.
Right.
That's only 3 of them.
And you can tell them that too.
What are the other 3?
Well, you can, how about my right to plead insanity? That's another one, you know. And
Non-substantive.
yeah. And they tell you that you only have 3 options. You know, well, I object. You know, why are you trying to coerce me? You know, is this all to extort money from me? You're coercing me into believing I only have 3 options? When you know as well as I know that there are more options, there are 3 more other options, you know. How about insanity? Or, I can't pronounce that word you just said.
I can't even.
Non-substantive?
Yeah. And there's another one too, and I can't think of it right now. Well, that was the one option they give you, but so you object right off the bat, you know, because how can I make a plea? I haven't even seen a copy of the verified complaint. And you want me to make a plea based on that? You object to that and say,
That's
I
only a
want,
promise to appear.
right,
That's all it is.
exactly.
Yeah, he tells you that when you sign it. This is not a plea,
Right.
it's just a...
Promise to appear.
Well, you can also say, I don't understand. So even if they do present something, you can say, I don't understand, I can't enter a plea for
And
something
he'll
I
say,
don't
well, I'm going to
understand.
enter a plea for you of not guilty. And in my case, I would say,
Said Jeffrey.
and I've told judges that I can't make a plea. You know, you don't hold jurisdiction to hear me make a plea. And I understand that my refusal to make a plea will involve you entering a plea of not guilty for me, and I object to you entering a plea of not guilty for me on grounds of lack of jurisdiction to do so. And tell them, I want this on the record. You know, I object. For the record, I want it on the record.
I bet that freaks them right out.
Oh, yeah.
You know, something I've been thinking about, I haven't quite figured out how to work it up, a piece of paper to put in for them. If you look in the Code of Criminal Procedure, it says not guilty means that you're denying every aspect of the information or indictment. Well, there isn't one.
Right.
So, I'm trying to work up some way to put something in front of them that if I plea, or anyone enters
A plea for you.
into the court records not guilty, that implies the presence of the information or indictment, and whoever would be doing such a thing would be creating false information in court records.
Falsifying government documents.
That's what's so
Submitting a false instrument for filing.
Right.
That's been 20.
That's what he's doing. Because he's filing.
Right.
He's not only is he generating, creating uttering the instrument, he's also filing it.
Yes, he
He's
is.
handing it to that person right next to him.
But from
Put that in the record.
13 cases in municipal court, I'm just telling you from personal experience. In the county criminal court, I got all this in.
They're not used to this down at municipal. They think everybody just caves.
Right, and they're not going to allow you, and the only thing you can do is object to it and say, I want it in that record that I object to you entering a plea of not guilty for me, and then go after them for fraud after the fact.
So how did you get into county criminal court?
Because it's classified differently. It's a different classification. Driving on a suspended license is a higher criminal. Yeah, it's higher than a Class C.
So now what's going to happen when you...
See, that's what's important about this complaint. The reason you always want a copy of this complaint, because you don't know what's on that complaint. You don't know what you're being charged with. You might think it's a little not wearing a seatbelt or whatever, but until you see that verified copy of that complaint, you don't know what you can't plead to something without your complaint and see what you're being charged with.
Well, actually, you really can't plead to a complaint because whoever complained, it could be anybody. They think there's something been done wrong.
Well, it's a county
That's
code,
why it's
son.
supposed to go to the attorney, and he finds a specific law that they believe has been violated, and that's what you plead to, is the indictment or information. But you really can't do it to a complaint because they vary so much.
Try this on for size. This case that I followed the motions in, they set it for trial and then changed it to hear motions, and I never made a plea. I have not yet made a plea. Remember I told you guys, I told them I couldn't enter a plea. They didn't enter a plea for me either.
So what is your
A
question?
plea has never been
Another
entered.
thing, these things in these lower courts like this, you're not supposed to enter a plea until the jury's set. Or you waive right to jury.
Right.
Is there some kind of a flow chart? There's some kind of a flow chart of how the proceedings are actually supposed to progress, you know, from that initial arraignment stage. You know, should they have not allowed a plea? I mean, that sounds right. If there's still motions to be heard, then not allowing a plea sounds correct.
Right. But the standard practice is
Standard steamrolling cookie cutter
is
stuff.
that you enter a plea
Pay your money.
prior to going to trial. And no, you don't have to pay money. You know, you enter a plea. The first day you go to the municipal court, you can go pockets empty, don't matter. And no, don't get all excited and everything, because all that's going to happen that day is you're going to say, guilty, not guilty, I object, blah, blah, blah. And that's it. You're not going to be heard that day. You're not going to get to set a seat jury members that day. Or none of that's going to happen the first day in a regular standard traffic citation. The first day you go to court on that promise to appear is going to simply be to make a plea. And then after that, they'll say, okay, this is your new court date, and this is your case number, and they'll give you one of these. And then you know when your date is and what court you're going to be in now, especially in municipality, because they always change. You might show up for the arraignment to make a plea in court 8, and then they set trial for court 3. So filing motions into court 8 is going to help you. It's the wrong court, So don't even go there till after you entered in that plea. And then you go in and you do your motions and you go file them with the clerk. And you've got to have 3 copies, one for the attorney's office, one for the judge, and a courtesy copy. And then you need a 4th copy so that in case they lose all 3 of those, you can say, hey man, look here, it was filed right here. See, I have my original received in district clerk's office, file stamped right here. And if you don't have that to prove, then they'll say, well, we're not going to listen to any of these arguments because you don't have, you put it in writing. And I've had them do that to me at the municipal court.
It's so important to get them file stamped, because the only thing that's file stamped is the only thing that you can use in court.
Yes.
It's like certified mail. If you don't mail it certified, they turn around.
Right. And you got to be careful with that. We've learned that, especially with the IRS in court, we went to court and said, look here, man, here's my certified copies right here. Well, we sent them in to you right here. He received it. And they said, well, we'll bring him in. And he goes, oh, yeah, I remember that. I signed for it, and I never could figure it out why they sent me an empty envelope. There was nothing in it. See, that's how they'll get around your certified copies. So what you do is you send a letter saying, I certify under oath that I mailed these documents pertaining to James Harden to the IRS district manager on said date, And then you send a certified mail. Now you have a witness, Hey, I know what was in there. I helped him put it in the envelope. That envelope was not empty. You see what I'm saying?
It's called proof of service.
Yeah.
I'll tell you another way you can do it too, because they charge you by the weight when you make it.
Yeah. How's that empty envelope weighing? Why I get charged $8 for an empty envelope?
That's a real human day.
Okay, James, what's happening Wednesday?
Wednesday, I'm going to municipal court, and it's set for trial for expired registration and vehicle inspection sticker.
It's totally separate
from this county criminal, yes. And what I'm going to do on that day is say, look, here's certified documents from the state and from me showing that I faxed them this information and that they realized that they did get this at the state and realized that somehow they lost it. And whenever they got copies of my certified mail receipts and stuff by fax, they immediately reinstated it. Now here's the letter from them saying that if I don't comply with these things, then they're suspending my license, registration, and vehicle inspection. Well, under those conditions, how could I have gotten it reinstated? How could I keep it up to date? It was under suspension status, and now here they've admitted that it was an error of the state by evidence here. Here's what I faxed them, and the following day my license was reinstated. See what I'm saying? Yeah. And they're going to go, oh, okay, dismiss.
This is not an arraignment.
No, this is supposed to be for trial for that.
So you've already had the arraignment on this thing?
Yes. And I pled not guilty.
Okay.
And so now I'll show up, and most likely, to tell you the truth, what's going to happen is other than one time when we cleared out every jury member in the courthouse because they weren't members of or judges of my peer. They always take me into a side room every single time. They take you into a side room, and they're like, all right, I'm offering you one more option, you can do this or that, and we'll dismiss this, and that's when I'll say, dude, look, here's my stuff right here from the state, showing the state was in error, and by that error, I was bound to an impossibility. It's a maximum of law that no man is bound to an impossibility. So, since no man is bound to an impossibility, and the error was on the state's behalf, how are you going to hold me guilty and find me of something that was an impossibility, And it was the error of the state. And he'll go, let me see that, and he'll look, and he'll go, oh, okay, dismiss.
So he'll dismiss this thing on Wednesday.
Oh, yeah. And we won't set a jury.
And then what happens?
Well, then that's just one more case where I can show the harassment. I've been to court 14 times, and I've got 13 dismissals.
Okay, but then what's...
For the same stuff. I mean, why are you harassing me? Why do you keep bringing me back in here for the same charges?
That's a separate case, though,
from the county criminal.
22nd deal.
Yes.
So now, they are related.
Yes, except what happened is I had an officer that wrote me for the registration and stuff that day who had character as to where these other guys didn't. The day I got arrested, I wasn't even driving. They arrested me for driving, and what happened is we show up in her Mustang to get the motorcycle because my international driving permit is covered for motorcycles too. And I show up there and because her brother-in-law didn't have a motorcycle's license, so they were going to tow the bike and he was going to be stranded because he didn't have a motorcycle's license. So she calls me and goes, you got a motorcycle's license? I said, I got a motorcycle permit, yeah. And she goes, well, can you go get the motorcycle for us, and give him a ride home? And I go, no problem. So we go over there and I hand him my international driving permit and stuff, and he goes and looks up my name off of it and comes back and arrests me for driving on a suspended license. And that's why I'm suing, because I never got on the motorcycle.
Now that motorcycle incident, that was where they discovered that you had the warrant for having the suspended license.
No warrant, no. I just had a suspended license. And so he arrested me for driving on a suspended license.
So he gave you 2 tickets at the same time.
Wow. There was
a
never
suspended license. You weren't even driving.
There was never a warrant.
Well, how'd you get there?
We pulled up in her Mustang.
Well, she drove you.
Yeah.
And then I get out to drive the motorcycle. And I never got on it. And he arrested me.
So he gave you a ticket for driving with a suspended license. So
Right.
that sent you to county court where you just told us all about that.
Yes.
Okay. Was it that same traffic stop that brought you to this trial Wednesday?
No, it was the previous one.
Previous.
And what happened at that point in time, we were going down 43rd, and the officer sees my stickers were out, and he pulls me over, and I said, look, here, I got these paperworks, and I'm battling with the state trying to get this, corrected, right now, and I go to hand him the papers, and he goes, that's all right, man, and he just writes me a ticket for the stuff. He took my license, copied the license, information, my name, my address, and license number and stuff on the tickets, and wrote me for the registration stuff only. He didn't run my license to see that it was suspended. And that's why, and he was a very nice guy. He comes back, says, I need you to sign this, that's what it's for, just be at the court on this date. He goes, you'll probably have it taken care of by then, you be safe. And he goes, and by the way, I've noticed you ain't got your seatbelts on, y'all should buckle up for safety. Totally how a peace officer should act,
Yeah.
And then today, I get pulled over by a stormtrooper, and he's in front of me, and I'm behind him. My stickers are all good and everything now. And he pulls to the side of the road, I pass him, and he gets behind me and pulls me over. and says he pulled me over because I don't have a license plate on the front of my truck. I got a Jesus is Lord plate instead there, and gives me says he's writing me tickets for no front license plate and for not wearing my seatbelt. I'm like, okay. So he asked me for my license and registration and proof of insurance, and I give it all to him. He goes back to his car, comes back and goes, you don't have a valid license. I go, yes, I do, man. I'm like, God, dude, they're going to try and take me to jail again, man. I'm all shaking and everything, you know. I'm like, I got to go through this again, man. Handcuff cuts and everything else, you know. Poor circulation. My thumb still goes numb on me and stuff from being in handcuffs for 2 hours over that incident. And so my heart's racing and everything, you know. And I said, here's the paperwork right here. I don't want to see that paperwork. I said, it's from the state. He goes, I am the state.
Yeah.
And I'm like, dude, I'm just trying to show you right here. It says to all public officials, you know, it could take up to 10 days and that I have complied with all these transportation codes and it has all my stuff has been reinstated. And I go, so why are you giving me a ticket, you know? And he goes, well, I'm just going to give you a warning on that plate, but I'm writing you for no valid Texas driver's license and for the seatbelt, and then gives me a warning that my back plate is the view is obstructed by the balls for the trailer. It's like, you know, why do you sell me a truck with only one spot to put the trailer ball and then give me a ticket for it? You know, again, bounding me to an impossibility. Show me a one dealership that sells pickups where the ball don't go there.
Yeah.
You know?
Right.
And so anyway, I go, well, so you're going to write me a ticket for no seatbelt? And he goes, yep. And I go, what law says I have to wear a seatbelt? And he goes, Texas law! Like that, and hits his hand on my door and hits me right here, man. So I went down, filed a complaint against him today with the Harris County Sheriff's Department for assault, harassment, and threat of arrest, because not only did he assault me and harass me, but he writes me the first ticket at 9:45, and that's this one. At 9:45, he writes me a ticket for failure to display valid driver's license and ride not secured driver, you know, no seatbelt. And then warnings me for no front license plate and obscured rear license plate. I mean, the dude's just totally harassing me, right? And then he, after doing all this, I'm pretty shook up, you know, and I sign it. So I sign it under duress, you know, because of the way he's acting to me. And he hollers over at his partner, sign it under duress, eh? You know? And I'm like, man, I just want to get out of here, you know? So I take off, and I'm half a mile up the road, and he pulls right up on me, tailgate me, man, for about 2 minutes.
You should have hit your brakes.
Yeah. That would have been great. And he pulls me over again. He pulls me over again and writes me a second citation at 10 a.m. for ride not secured driver, and threatened to arrest me if I didn't put my seatbelt on. So,
Well, he must have a warrant then. If he's going to arrest you, you have to have a warrant.
Right.
well, not only that, but no man can be tried twice for the same offense, much less in the same 15-minute period by the same cop on the same road. You know?
Yeah.
What's up with that? I mean,
That's exactly the kind of weak mind that I was talking about before. They have to hire people that are like him to have the
bully
whatever,
mentality.
yeah, to have the arm, the push around power,
Strong arm
to make
tactics.
people you will obey.
Yeah.
Texas law.
Texas
law.
That's what he told me, just like that.
He's a weak mind. He's probably, you know, money is this guy's got.
Well,
You
put
should
it
have
on
told
the
him.
stand and he'd be the same in the neighborhood if he wouldn't know where it showed me in Texas law.
Right.
Where is that?
Yeah.
He'd be
Oh, yes,
stuck.
I saw a trial recently in Galveston County where they had the cop up there, and basically the guy, first he brought the transportation code and other things that he had, and the prosecutor objected really it's because he hadn't described it into the record what it was. He's trying to get into evidence.
To use
So he goes back down and he looked on the prosecutor's desk. Well, he used this one. It describes it a little bit, and he objected to that, and the judge said, well, let me look at it. Well, he thought this was okay, you know, and then he gives it to the cop to look up the law that he was attempting to enforce on
Right,
him.
and he couldn't show
And then
him.
he just stayed quiet. And after about 10 to 15 minutes, I think the judge was getting embarrassed. He had the jury take a break, and they went off, and he'd look up at the prosecutor every now and then, you know,
Like,
how do I do it? Help
what
me.
page, right? Where do I go? They don't
They're out for
know.
a while, they come back in. He still hadn't found it, you know. And,
Well, they're taught procedures. They're not taught the law.
They're violating their oath.
So there you have it, everyone. That concludes the video. And so, yeah, educate yourself, you guys. That way you know what you can do in the court. And so be safe, and everyone have a golden day.